Hello, welcome to my channel, and in today's video we shall look at acceptance. By definition, acceptance is the indication to enter into and be bound by the contract. It is a positive response to an offer. In other words, acceptance creates legal relations between two or more parties. Acceptance can be in writing and in oral form or by conduct. Communication of acceptance. So the general rule is that acceptance must be communicated to and received by the offerer. Thus, if acceptance is not received because of interference on a telephone line, or the offeree's words are too indistinct to be heard by the offerer, there is no contract. It is a condition that therefore silence cannot amount to acceptance. This rule was stated in the case of Feldhaus versus Binley. So the plaintiff wrote to his nephew offering to buy one of his horses, adding in quotes, "If I hear no more about him, I will consider that horse is mine at £30 and 15 pence. The nephew did not reply, but told the defendant, who was an auctioneer, not to sell the horse to anybody else. And the defendant sold the horse by mistake, and the plaintiff sued him for damages. The issue was whether silence by the nephew amounted to acceptance, and the court held that since the nephew had not communicated his acceptance to the plaintiff, there was no contract of sale, and the auctioneer was not liable. Court therefore concluded that silence does not amount to acceptance. And the acceptance of the offer must be absolute and unqualified. The offeree must accept the terms of the offer as made to him. He must not change them. Any change of the terms creates a counter-offer, hence no contract, as was illustrated in the case of Heidi versus Range. And another point is that the offerer may explicitly state the method of communicating acceptance. Acceptance must therefore be communicated to the offerer in the manner stated by him. Then another point is that acceptance must be communicated by the offeree or by someone with his authority. And this principle was stated in the case of Powell versus Lee in 1908. Where the plaintiff applied for the post of headmaster of the school, which was run by the defendants who were the managers of the school. So he was called for an interview, and the managers passed a resolution appointing him, but they did not make any arrangements for notifying him. However, one of them without authority informed the plaintiff that he had been appointed. The managers subsequently reopened the matter and appointed another candidate. Plaintiff sued for breach of contract. The issue before court was whether acceptance was validly communicated to the plaintiff. So court held that his action for breach of contract should fail because the defendants had not properly communicated acceptance to him, since the person who communicated had no authority to do so. Acceptance is not effective if communicated in ignorance of the offer. So we also have exceptions to the communication of acceptance rule. So there are certain exceptions to the rule that an acceptance must be communicated to and actually received by the offerer. These include the following. We have unilateral contracts. These are contracts where the offerer consists of a promise to pay money in return of performance of an act. In such cases, performance of the act is sufficient acceptance. Then we have the postal rule. An acceptance by post is effective as soon as the letter of acceptance, which is correctly addressed and stamped, is put into the postal box. Immediately a binding contract is created between the parties. This rule was stated in the case of Adams versus Lindsay. And NB, if the letter is lost or delayed in the post because of the offeree has addressed it incorrectly, the postal rule will not apply. Posted means put into the control of the post office in the usual manner. Thank you for watching. Please endeavor to subscribe, comment, like, and share with your friends. Thank you.